Hello, everyone. Welcome at the last session of this conference, a very important one dealing with excessive pricing, the new confusion. Are firms more exposed under competition law or consumer protection laws? We have a very, very esteemed panel for this discussion, and I really thank you for your presence today and all of your preparation. It is Prof Nicola Theron. Prof Nicola is an expert competition economist at FTI Consulting. Thank you, Prof. We have Albert Aukema. He's a director in the competition practice of CDH in South Africa. Welcome, Albert. We have Mr. Hardin Ratshisusu. Hardin is the acting commissioner of the SA National Consumer Commission and Deputy Commissioner of the SA Competition Commission. We also have Chukwere Izuogu. He's a partner in the competition practice at Streamsowers Köhn in Nigeria. Ladies and gentlemen, thank you so much for your great insights tonight. I'm going to start with a quick intro in relation to this topic. Many African jurisdictions have established or still in the process of establishing consumer protection regimes. And the establishment of consumer regimes are often part of a threefold development that includes the establishment of a standards authority, a consumer authority, and a competition authority. And it's normally in that order. Many African regulators have the dual mandate to enforce both the competition and the consumer protection laws. And for many years, African jurisdictions, especially South Africa, have enforced excessive pricing provisions under the Competition Act, and these cases have been fairly difficult to analyze and to prove. But more recently, an increasing number of decisions on the charging of an unfair, unreasonable, or unjust price or unconscionable conduct have started to see the light. And these decisions were made under the provisions of the consumer protection laws. And whereas businesses have become used to the stringent tests of excessive pricing under competition law regimes, the tests under consumer protection laws appear from the outside to be a little bit less rigorous or not clear at all. And today we are going to discuss the differences between these two tests and to give some kind of certainty to business and even regulators who are still finding their feet in this regard. And we are happy to have an immensely resourceful panel to discuss this particular topic. And I'm going to start with Chuck. If we look at the first issue of the differences between the legal and the economic tests, between the excessive pricing regime and the consumer protection regime, can you give some kind of indication from a Nigerian perspective? What are those differences in the legal tests and the economic tests? Thanks.
Okay. Thank you, Odie. It's a pleasure to be in this wonderful midst of wonderful people. So back to your question, just to give you some background, our consumer protection and our competition legislation are actually embodied in one single document.
Correct.
So we have the competition authority enforcing competition law, then we also have the competition authority acting as a consumer protection enforcer. So in terms of your question, when you look at excessive pricing and what kind of legal standards would apply, I'll tell you that it's under the Competition Act, it basically could go either on the basis of excessive pricing, which is provided for in Section 72 2A of the Competition Act, and obviously that is a competition infraction, or it could go on the basis of Section 127(1)A of the Competition Act, which is a consumer protection provision. Now the difference is that when you decide to pursue an infringement on the basis, an excessive pricing infringement on the basis of Section 72A of the Competition Act, it automatically translates to an abuse of a dominant position. And there is an analytical framework for that. I mean, obviously, for those of us that are very conversant with competition law, we know this generally involves the first stage would be defining the relevant market, which comprises of a product market dimension, and a geographic market. Then you also have to establish that the firm itself occupies a position of dominance, and according to the decisional practice of the Competition Authority in Nigeria, which is FCCPC, there's a presumption that a firm that controls at least 40% of a market, is presumed to have to be in a dominant position. Then you also have to demonstrate that the price which charge is excessive. I mean, simple. I'm not an economist, and I'm sure Professor Theron, if I'm correct, to call me to order if I'm wrong. But simple economics tells me that a price is excessive when it is above, when it's significantly higher than what should ordinarily be charged within a competitive market. Then if that is established, then basically from a competition point of view, then that translates to an abusive exercise of market power by implementing an excessive price, But for as long as I've practiced competition law, I know price-related abuses, especially excessive pricing, are usually very, very difficult. There's jurisprudence on that to prove, to establish, but on the legal standards that apply if you decide to pursue it as a consumer protection infraction, the standards are very, very much not as rigorous as what you would find when you pursue under the competition pathway. Basically all you just need to establish is that the price is unfair, unreasonable, or unjust, and it gives the regulator some level of flexibility in how to intervene, especially if the prices are arbitrarily increased to the detriment of consumer. And we've seen cases of this, for instance, price gouging, which was very rampant during the COVID period, in which the FCCPC intervened, on the basis of that provision, and they made a determination that the prices were actually unfair and they exploited consumer, and these are just instances, and these are how the standards would be if we decide to pursue on the basis of competition infraction or on the basis of competition law infraction. Thank you. I hope I did justice to that question.
Yes.
Thank you.
Thank you very much, Jack, for that. Hardin, can you possibly, from your perspective, having wearing two hats at two different institutions, can you also, just from a South African perspective, differentiate those two tests from a legal and economics or pricing test perspectives? And maybe if you can also indicate whether there are instances where the Competition Authority and the Consumer Authority will trade cases whenever it is more convenient. Because in South Africa, we don't have a combined entity, we have two different entities. Thank you, Hardin.
Thank you, Odie, and thanks for the invitation and for arranging this a very interesting, conference. I hope it continues. It sounds the program looks quite interesting. So thank you very much.
Thank you, Hardin.
Where we are in South Africa is we do have two pieces of legislation, so which is the Competition Act, enforced by the competition authorities, and the Consumer Protection Act, enforced by the Consumer Protection Authorities. The legal framework, and of course, looking at the competition side, it looks at, of course, excessive pricing, but I must say the idea and concept of excessive pricing bears some controversy, because it's not many authorities that are looking at these issues.
Mm.
I think even for South Africa to have provisions for excessive pricing, it's something that I think is continuously debated, with around the world, whether should competition authorities intervene on pricing. Be that as it may, the law here, of course, the standard it's a bit higher. It's based on we look at the abuses. So excessive pricing is a form of abuse of dominance from a consumer competition protection, from a Competition Act perspective. But the key thing there is even the concept of market power. Because dominance is one thing, but a firm should be able to exercise market power. There are some thresholds to this, so which is why I sometimes think that the Competition Act is also equally quite expansive, because though there are market share thresholds and some, parameters, a firm could still face some risks, even with very low market shares.
Correct.
Right. Technically, this is what the law says, right? But the key thing is to assess whether that firm has market power or not. And I think there was a case, was the Metal case, where the tribunal tried to define these parameters, but the court cautioned against that, because the tribunal was sort of taking a view that maybe excessive pricing should be really a species of conduct that is targeted as the super dominant firms, so the very large firms. But the way the laws have been structured is that as long as a firm is dominant, exercises market power, it can be dominant with very low market shares. Right? This is what it says. Likewise, when you look at the Consumer Protection Act, the test is different. So it's not a market power test when I look at it. It's really a test of fairness. So it says, are the prices fair or reasonable? This is or just in any way. So this is a fairness assessment, which means that would depend, I suppose, on context and markets and the use maybe of that particular product in any given space. And this is an area that, at least from a consumer protection point of view, we have not seen much enforcement, at least in South Africa.
Yeah.
The issues that consumers are worried about are other, terms and conditions issues. I think most of the consumer markets in South Africa, in my assessment, are quite competitive. So it means consumers do have options, right? But there could be instances of, exploitation or possible exploitation. But in most cases, consumers do have options. So what we see a lot is concerns around terms and conditions. That's why I think the colleague has mentioned COVID-19. The only time when this instrument was being used aggressively was during COVID-19 pandemic, where government even had to publish a regulation. But the regulation really provided quite extraordinary circumstances. So I don't think it's a test that you're more likely to use into the future, that says if your margins are higher than X, or higher than they were 3 months ago, you are deemed to be exploiting consumers. It's the same test that was applied under the Competition Act, which is very interesting. That's why I say, these acts in South Africa, when I look at it, depending on circumstances, they can all be very flexible to the point where, in that case, this very same case, there's a case, Babelehi, that was fined for, increasing the prices of masks by very huge amounts. And it was a very small firm. Very small firm. But because the Competition Act is flexible enough, that firm could attract liability. The court even called them like a monopolist at a particular point. But because the law, it allows, market power, I think it's a very interesting and dynamic concept. The same with, if I look at consumer protection, it's a fairness test, which has not been fully explored. But this is something that I think when I assess, it also serves as deterrence for firms. So the standard is there. So you're not finding firms, doing things that attract the attention of authorities, essentially. They aren't unusual, just random price increases, because if those things happen, this is where you could potentially invoke your consumer protection laws. But those things are not, happening in a way that I would say you need to intervene in a more aggressive way. But the instruments, maybe the point I'm trying to make is that these instruments, I think they are both flexible. Very flexible. I've had this idea that the dominance ones, the buy is very high and all of that. It depends on the situations. It depends on the market in question, the product you are dealing with. It could be even complicated in the consumer protection space, because if you charge a company for unfair pricing, the EU, that's the EU standard, by the way. So the EU talks about fairness, right? But it's quite a rigorous process to determine whether a price is fair or not. I don't think because the standard looks low,
but it is.
It means the burden of proof is lower. Because you may still need to follow the same, price metrics or cost metrics you follow in an excessive pricing case. There has to be some comparison, cost comparison, relative to the price and so forth. So I wouldn't give you like a direct answer, Odie, to saying consumer protection law standard is very low.
Yeah.
It can just be used willy-nilly. And then the competition protection one,
it's very
the
high.
Competition Act, it's a high bar. I think both require some burden of proof. I would submit. Thank you.
Yes, thank you very much, Hardin. Can you quickly indicate to us whether you have seen the trading of cases between the two authorities? For example, if you get a case of, let's say, something that looks like a high price, is that something that you would call your colleagues at the National Consumer Commission and say, I think this is more something for you to analyze? And vice versa.
Yeah, we do. Yes, indeed. We do have referrals. So we have a memorandum of understanding. So if you pick a case that, but it's not a lot, right? So as I've said, consumers are are more worried. The complaints we get are more transactional issues.
I see. That's very
Right. So this
interesting.
is what you get.
Oh, I see.
Even if you look at the competition side, the pricing cases you have, sometimes they are even at a higher level, between at a business to business
Correct.
relationship.
Mm.
I do see a lot of complaints from consumers. Consumers sometimes when they complain about prices, you find that the person is complaining about like a single product. They just say a price increase 7%, okay, or 10%, whatever the number. It's very difficult to really intervene in most of those cases, right? So that's why these cases are very few.
I see. Yeah.
In a way, but I think we do have that mechanism.
Yeah.
But we don't have a case that I can say to you, no, we picked it up from the commission, done by the NCC. It was during COVID where we could pick those related cases.
Correct.
Because there, almost all complaints, about 3,000 were about price.
Yeah.
That the price of ginger has gone up,
Yeah.
price of mask has gone up, and so forth. So that was the main issue then. But right now, for me, I'm not picking it up as a big area of concern from consumers in South Africa.
Yes. Thank you very much, Hardin. Albert, I recall that you wrote an article about 3 months ago about the distinguishing features, or how can we say the differences, or your experience of the Cell C case. Can you share your thoughts on this perceived differences in legal and economic tests between excessive pricing and consumer protection, let's say unfair, unreasonable, unjust pricing?
Sure. And thanks, Odie, for the opportunity. I think, it was very interesting to me to read that decision, because it came out of the Consumer Tribunal. So it's the body decision-making body that deals with cases that are brought to it under the Consumer Protection Act. And in the main, it dealt with what looks very much like a consumer complaint. It dealt with a consumer complaining about being charged very high roaming rates when that consumer was traveling internationally, after she had asked for a limit to be put on her account. And most of the decision, I think, quite rigorously, and it's a carefully considered decision, sort of focused on the consumer aspects of it, which is, how do you deal with someone's request for a limit, and the practical difficulties that sometimes these limits don't work when you're overseas, because there's this delay that comes in. But just to bring it back to this question, what the Consumer Tribunal then did is it used Section 48 of the CPA of the Consumer Protection Act to say that not only was there some unfairness in how the consumer was dealt with, but we also think that the price that the consumer, if this had been a pricing question, and you had asked the consumer or you had considered what the consumer was being asked to pay for the data, and on any measure, I think it's shocking. It was about $500 USD or 8,600 Rand for 100 megabytes. So, sort of, it shocks you just to think about that. We think that this price is in contravention of Section 48 of the Act, and it alerted me, at least at that stage, this very clear tension between the excessive pricing provisions in the Competition Act and then this quite simple provision on the face of it in the CPA that says, look, if the price is unfair, unjust, and unreasonable, and for that you sort of, it basically puts two qualitative tests in place. It says, and you ask yourself, is it excessively one-sided, or is it so adverse as to be inequitable? Sort of the tests, and I think they're very similar to the Nigerian tests. Then you can make this finding that a price is unfair, and it can have quite wide-reaching consequences. Now, you can, and I think, and I don't want to go into Nicola's territory on this, but nowhere in that primary provision do you find the guidance that you find in the Competition Act, where we basically have this two-stage test that comes from case law, which is, try and find out what the competitive price is, or determine a competitive price, and then do your value judgment, your assessment relative to that with a whole list of technical factors taken into account. And I think that sort of thinking about the differences between the two provisions, it makes sense. The one is and I think Chukwere and Hardin have pointed to this. The one is the Competition Act deals with it. This is probably the primary difference, deals with it in the context of abuse of dominance. So not all firms have that special responsibility to act responsibly on the market. Only dominant firms have that responsibility under the Competition Act. Whereas the Consumer Protection Act, on the face of it, might extend it to a broader set of firms that have the responsibility not to contravene the section, but it only protects a very limited set of, it protects a much narrower set of stakeholders. It protects consumers. So it protects the individuals and really small businesses that are basically alter egos for consumers. So I guess you can say that there's some sense in having a simpler test in the CPA, but the question that I have, what I'm grappling with is, and there is a provision in the CPA which says you must, when applying this section, you must ask yourself, what is the fair value of this good, right? Or this service, and what are other people charging for the same good or service? And that's about as far as it goes, But the question for me is, it's very difficult and somewhat tautologist to try and apply notions like inequity and one-sidedness when assessing fairness of a price, right? It's circular to me. And the best I can come up with there is to say, look, it must be that those things represent some form of materiality threshold. So I agree with Hardin there to say that I don't think that the Consumer Protection Act sets a lower bar. It tries to probably create a simpler regime, and whether or not that will work in practice, we'll have to see. It certainly worked in this case. I think the reasons were issued in 5 days, after the matter was heard, which that in itself is quite something, But I mean, there's no economic analysis that's involved in the process, no real attempt to try and get even to a fair value for the product. It stands in stark contrast to the complexity that you would have in a competition assessment of an excessive price.
Thank you very much, Albert. And if one considers the EU standard, which is basically the same, based on what Hardin said, which is absolutely true, then one would actually then expect that if you go that route, there would be some kind of a rigorous analysis. So it is quite interesting. And maybe before we get to Prof Nicola, Hardin, would you foresee that in the future at the CPA, at the National Consumer Commission, that some kind of a European test, analytical test, would be applied?
So my sense, and by the way, it's my approach getting these kinds of cases, is that if you want to attack a price level, right, so it doesn't matter which standard you want to apply. It could be unfair because we think it's too high, or it has been abruptly increased. There has to be some assessment. Right, so I'm not, and when Albert is referring to this case, the Celsi case, that's why I said to you, most of the issues are around terms and conditions. And the tribunal there is talking a lot more about the duty to notify and communicate in time. Right? Not so much. So that that conduct on its own, they say it's unconscionable. So you're doing it to exploit, right? So it's conduct targeted at exploiting consumers. Right? So you are hiding behind some, terms, and then eventually you exploit consumers. So those things, I would think, maybe Albert, I don't think those, because when I was looking at this, I was looking at it from a pricing point of view, right? like a price of a good in a market. Let's say bread prices increase tomorrow. The firms are dominant. Competition Commission wants to intervene. Consumer Commission wants to intervene. I don't think you can sustain it. You can say, well, this case is going to be simpler because I'm applying Section 48. Right?
Yeah.
I cannot, otherwise then it becomes so arbitrary. Then it means I don't think it's possible. I must say, I don't think it's possible for an authority to just wake up and say this price is unfair. Right?
No, that's fine. That's the that's what I thought, because I read it from a consumer perspective. I thought to myself, this is pretty rigorous, and looking at this issue of fairness and the balance of powers between consumers and suppliers quite carefully. And then you get to this, and it never struck me before. You get to this finding that says, it looks at that specific finding in 48, and it says this is in isolation, the price is unfair. You should be sanctioned for that.
The only thing, though, with the Consumer Protection Act is that you will not be caught in the technicalities of market definition, right?
Principle.
Market power. You deal with the issue.
Exactly.
Right?
Yeah.
Can you see? You deal with the issue, which means that's why, as I say, I think the provision on its own does provide some deterrence. That firms because it exposes any firm.
Prof Nicola, can you give us your views on the differences from an analytical perspective?
Yes, absolutely. Thanks, Odie. I've also been following the discussion. Very, very interesting. I think long overdue to unpack these issues. I think Adine and I have come from an economic point of view. So, Adine, I'm very glad you said that these exploitative pricing regulations or provisions are obviously controversial from an economic point of view. But I think that also helps to understand a little bit the difficulty between the tests, because essentially, if you go back to principles and you consider what Motta has said, he talks about very dangerous provisions to think about a price that is too high. And I mean, the whole problem is that this degree of arbitrariness when you decide when a price is too high. So we find that under the Competition Act, excessive pricing, but we also find that obviously under the Consumer Protection Act. So maybe just a few thoughts about that. So when we apply the excessive pricing test, Competition Act now, we have to define what is the current price. So what is the actual price? Then we have to work out what is the economic value. And I think that is where the Competition Act actually helps us, especially the amendments, because now, we know that we have to look at the price cost margin. We know that we have to look at prices in comparable jurisdictions, and the Commission has issued guidelines on the price cost margin. I think you finalized in March this year.
Correct.
So that's very interesting. But once you have applied that economic value test, you then have to say, is it unreasonable? And then you have to think about detriment to consumers. And that's obviously this complexity in determining the fair value of the economic value. I mean, that's why we've had the Sasol and Mittal cases. That's why the tribunal decides against Mittal, the CAC, overturns that decision. And if you look at the different standards in Sasol, just on how capital is allocated, you can see the complexity there. So I think from an economic point of view, I still, I like the test in the Competition Act because it gives us, it speaks to the economic idea. So if you think about the test for a monopolist, for dominance, it's the small but significant non-transitory increase in price. So that non-transitory tells you that you must consider the duration of the market power. And then you get to this idea of, what is the price level? And then you go through your tests where you compare that to cost, for instance. Now, I think where this is, for me, become a little bit more difficult is in the consumer I think the 19th of March in 2020. So again, we have COVID, we have an emergency situation, and very quickly we get these consumer regulations. And they are based on both the Competition Act and the Consumer Protection Act. So it's interesting. I mean, they take Section 120, I think, of the Competition Act, or the Consumer Act, and they combine that into these regulations. And I think that's where we then end up in a world where babelegi is dominant and where babelegi has temporary market power, and Dennis Davis calls them a lucky monopolist. So Adine, you're right, we acted for them. We actually acted for them pro bono because they're so small. But that was also a very interesting case, to see. And I think what happened then is we had that specific period, and Adine, I think I'm glad I hear you saying we probably won't apply those criteria again, where you had that 3 months and you had the temporary market power. And of course, babelegi had very large increases there. So, they passed that test in terms of, is that price unreasonable? But I think from an economic point of view, it's very difficult to think of a firm that is exploiting consumers, but they are so small, and they're selling final consumer goods, because that's the other thing we see, obviously, from the Mittal and Sasol cases, or these are intermediate goods. These are monopolists with a long history of market power that then charge a very high price, and that has an effect right down the supply chain. So just to compare that then to the Consumer Protection Act, I think, there it sounds to me simpler. I don't have much experience with that, in the sense that you then consider the final consumer. I think Adina's also said, generally they have choices. I think the unfairness makes it, again, very difficult, because you will, again, have to apply your economic analysis. What is the competitive price? What is the deviation from the competitive price? And I mean, we have had now since 1999, from the Commission started in 1999, I mean, the Act in 98, over all these years, we haven't managed to really develop specific criteria for excessive pricing. So I think the Consumer Protection Act obviously still has a very long road to go in terms of developing proper criteria for applying what is unfair. But I mean, I think it's right that potentially you need to be more nimble, and you don't need to prove that a firm is dominant, because I think that's what tripped us up in the competition law arena. But from an economic point of view, the Competition Law Act, to me, feels closer to what you want to police under an exploitative abuse. Thanks, Odie.
Thanks very much, Nicola. And if I go back to what Adine suggested, listening to all of you, I'm wondering whether it may be a situation of not necessarily checking whether the price is unreasonable or the price is unjust, but whether there was conduct that was unreasonable, conduct that was unjust, which had a price effect. So maybe the assessment is not so much as to whether the price is unreasonable, but whether there was a preceding conduct, like in the instance of Cell C, where they basically just ignored their own terms and conditions, and that ended up in a massive bill for the client. Hardin, I'm mindful that we are already very far ahead in terms of timing. Can you possibly give us an indication, if we look at the two regimes, what are the things that business must look out for? Because I'm mindful that businesses are used to the fact that they must only be dominant, in the broad sense of the word, in order to get to the risk of an excessive price. But that appears now not to be the case. You can also be in contravention of a pricing provision because of something that you did that was unlawful in terms of the Consumer Protection Act, whether it's unreasonable or unjust. Is this a fair comment? Or what would you say at this point of the developments? What is the lessons for business at this point?
What I can say, Odie, very briefly, is that my reading of this is that if you look at the objectives of the two legislation.
Mm.
So the other one is more, targeted at the market structure issues, which is
Yeah.
the Competition Act, entry, promoting entry, participation in markets and all of that.
Mm.
Whereas the Consumer Protection Act is looking at, just the welfare of consumers, including the vulnerable consumers, and they are specifically mentioned, right?
Mm.
People with disabilities, people who cannot really defend themselves, which means this law should be able to protect even just one consumer, not a class, just one.
Yeah.
So which means that how I look at it is that the test is flexible to avoid opportunistic pricing and some just random exploitation of vulnerable people. That's why I say to you, if you look at South Africa, let's say large firms, large retailers, mostly they are applying a national pricing policy, right? So you can see that there's equal treatment there. But there could be those that seek to exploit. In fact, there was a big issue in the informal retail. But maybe it's, the people were complaining about the merchant fees. We have not looked into that all of a sudden now they have to top up the price and they feel this is not maybe right. At least the Consumer Protection Act allows us to look into those issues. But I must say, I don't think, and I would agree with Nicola, that you cannot just look at something and say it's unfair, no matter how I may feel about the situation, no matter how that consumer may feel about the situation. We would have to make some assessment. Right? I think it's going to be, and that's why there's not like these sort of price-focused interventions were quite easy during COVID.
Yeah.
You have not seen a lot of cases from consumer authorities on pricing, taking those cases on, right? Because these are cases that must be taken on carefully. And you asked earlier, should we apply the EU standard? I wouldn't want to say that here, but the way it's crafted, it's on unfairness. But economic value comes from that very same standard.
Exactly.
Of unfairness in the EU, right? So it could be that if you take on a case can invite a lot of challenges. I don't think the firms can sit back. If I say to big bread supplier, I say, well, your price is unfair, right? I have to prove that. I don't think it's going to be enough. So at least it's not the approach I would take from the National Consumer Commission, right? If we take on a case, it should be a case that at least we have done some assessment. It's either that, a firm is increasing prices with no cost justifications or no cost increases whatsoever, right? Just random price increases. But that assessment has to be made.
Yeah.
And that's why I think the Act can allow you to intervene in those sort of opportunistic situations.
Yes.
In a way. But yeah, I would... but I just have to say, you have to think about just one consumer. It could be one person.
Exactly. Yeah.
Right?
Exactly.
Yes. So I think the law has to protect, that category.
Yes.
In a way. So I hope that helps in a way. But it's a very difficult question, this.
Yeah.
Because I don't have a case to you to say this is a case where we pursued in a normal course.
Yes.
Where we've taken on these kinds of cases and what was the guidance from the courts and so forth.
Yes. Thank you very much, Hardin. Chucks, if I can get back to you. Something that struck me when we were at the ABA conference was on one particular panel, the panel members was quite outspoken about the fact how much the FTC could use their skills on the competition side to help develop the consumer side, because that was then that became part of their mandate. And the FCCPC also has that particular mandate to look at both sides. And do you foresee that that is something that will happen? For example, if we look at the multi-choice case, would you also foresee that type of cross-pollination? And in addition to that, what do you think are lessons for the Nigerian consumer or business?
Okay, thank you. Thank you, Odie. Just to give you some context, the multi-choice case was, from my understanding and reading the case law, the decision of the court bordered actually on a competition infraction. You know, what happened exactly was that multi-choice made a press release that they were going to increase their prices for some of their services, you know, and the competition authority stepped in and said, no, you don't have to do that. You know, you have to stand down on that. And then multi-choice went to court to challenge that, you know, and at the center of that, you know, the whole storm in the court was certain provisions of the Competition Act. You know, when I say Competition Act, I actually mean Competition and Consumer Protection Act.
We don't have time for that.
Okay, yes, sorry. So basically, essentially, so the court did come to a conclusion that this is a free market economy. You know, you can actually, as a firm operating in the economy, you can actually determine your price. You know, you don't have to wait on the competition authority to put out your price, you know, and it actually threw out that case because there were some procedural errors. I'm trying to, because I'm mindful of the time here, you know, so that's it, you know, but, you know, if we reflect back in some regulated sectors, like the telecommunications, like the oil and gas sector, where prices are regulated, and then we have something like sort of like filed rate doctrine, which is popular in the United States of America. You see that in that kind of situation, you actually have to go and get an approval for your price, for your retail price from the authority, the sector-specific regulator, before you go to the market. Correct. You know, so sort of like multi-choice case wasn't really about consumer protection. It was an abusive exercise of market power that the competition authority tried to intervene, but there were some procedural errors they failed to comply with, and the court threw the case out. You know, and they didn't really talk about the merits of the case, but they said it was an abuse of a court process because there's exactly a case before the competition tribunal on the same facts against same multi-choice, you know, and they said, I mean, this is an abuse of a court process. We've got to take this out of here, you know. So, but essentially that was a competition infraction, not a consumer protection, you know, and we've not really seen a lot of consumer protection cases with respect to excessive pricing beyond what we saw during the COVID period when there was price gouging, you know, and it was just easy for the competition authority to come to an assessment whereby in COVID, it was sold at, for instance, ₦1. And during the COVID period, you can see that there's an arbitrary increment in that price with no justification. Correct. So, I mean, from a reasonable perspective, you can see that was actually exploitative of consumer considering the circumstance of the situation. So I think that's I hope I did answer your question.
Yeah, that's right. And it will be interesting to follow the development within the FCCPC as to whether there is that kind of sharing of knowledge and building of the capacity of each of these two pillars within the FCCPC. Thanks.
I'll be careful to speak here because I actually don't work for the FCCPC, so I don't want to get misquoted, So, but I tell you from my experience and my reading from the law and from the decisional practices of the FCCPC, this is what it looks like.
Yeah, perfect. Absolutely perfect. Albert, from your side, any lessons for business pursuant to the Cell C case or pursuant to any other case in relation to consumer protection in Africa?
If you're going to regulate prices or try and look at price levels or exploitation from a price perspective, it seems, and Nicola will probably agree with this, you're not going to get away from the economic analysis, right? And even the CPA seems to acknowledge that when it says, look at what the fair value of the product is. And probably because it lacks that more crystallized framework that we now have in the Competition Act, I think, if I understand Hardin correctly, it is that it is not your first best place to start looking at regulating a price, right? Which brings it back to the purpose of the CPA, which is, to try and take away that imbalance between consumers and businesses, right? And practically, if you ask me what would you tell a business, what would you tell a client, I would say, think about that. Think about whether or not you are using the inherent imbalance between yourself and your customers to extract higher prices without more, in a sense. So almost the question, it almost takes it back to a sort of intent question. So what is your intent with the course of conduct that you're following here? So, yeah, but I think, clearly the Competition Act and the regime that's built up there and the, sort of the entry requirement of dominance means that it's just so much more sophisticated for dealing with these issues. And it probably does a disservice to the Consumer Protection Act to try and use it as a primary tool to address pricing. I think it should be, and I think I agree with that in there, it looks at pricing, but it looks at it in a context.
Thank you very much, Albert, for that insight. Nicola, Prof Nicola, can you give us your final words in relation to advice to clients when they are worried about the exposure under the one or the other?
Yes, so I think it's very, very difficult for clients really to know what is expected of them, and I'll explain. So I think the way I think about it, again, from an economic point of view, is almost there's a continuum here. So Chuck's also talked about regulated prices. So from an economic point of view, if there's a regulated monopoly, let's say Eskom, then NERSA sets the price. Okay, so we know there's a complete market failure, no demand and supply signals, and a price is set by a regulator. Then you get to a point where you say, okay, if you are a monopolist, or let's say you have market power, you are maybe Sasol, Mittal, a large firm, then there's a special onus on you. And we know also, I mean, Albert can speak more to that, but we know the onus has shifted under the amendments. And we actually expected a lot of excessive pricing complaints subsequent to that, which I don't think we've seen. I don't think the Commission has seen many of those. But the point is that then you would know that there's special responsibility on you to price in a manner which is not excessive. But I think where it really becomes difficult is most of these tests tell you that you must sort of price in accordance with your cost, okay? Because those tests are mostly a cost-based test, and that's why I also referred to the price cost margin guidelines of the Commission. But the problem with this is that if you have a cost-based standard, it doesn't take into consideration changes in demand. So I can't say to my client, you must always just keep a 20% above your cost, because what happens if there's increased demand for that product? I mean, surely that client has a right to increase that price. Now, when is it too much? And I think that's where we then got into the COVID price gouging story, because I think from an economic point of view, again, I understand, if there's a Hurricane Katrina in New Orleans and fuel prices increase by 200% and you can't get fuel. I mean, I understand that is exploitative, but the question is what is in between? And, you know, I think the Babelegi one maybe also bears repeating again. I'm still upset with the decision because I think one has to have some sympathy for, you know, Babelegi is actually a region in Pretoria. This guy and his wife, I think, had this factory. And March comes, they order their face masks, and it's Easter weekend, and suddenly they have an excessive pricing complaint. So I'm not saying the court is incorrect finally. I'm just saying, you know, giving advice under those circumstances, I think, were incredibly difficult. So I'm hoping that there's more guidance now. But, I mean, advice is really, really difficult to clients. We don't have proper precedent even under the Competition Act in terms of excessive pricing. Then we have all these COVID cases that talk about temporary market powers. So, you know, what exactly is the relevance of that under the amendment now that COVID is finished? And then under the competition, you know, under the consumer protection regulations, you know, I don't think I'm the best person to advise, but it seems to me there is also quite a bit of uncertainty. So I think it is difficult to give advice to clients under these circumstances.
Thank you very much, Prof Nicola. And it's certainly something that we will keep our eyes on. And once there's something that appears to be significant, I think we should come together again and discuss the new guidelines or the new indications as to what is fair and unjust and unreasonable and excessive. It has been a great pleasure speaking to you. I hope this was of some value. It definitely was for me. I must say I've also learned a lot as a result of this discussion. And thank you very much to our panelists for your thoughtful contributions and for clarifying things to a significant extent as to where we are in relation to those two issues at this point in time. Thank you very much, especially because it's already late on a Friday evening. I did receive a friendly scolding from one of the panelists asking what they did wrong. It's been a great privilege to have this discussion with you. To the rest of our attendees, those of you who stood by us for the past 3 days, it's been a great privilege to have you here. Thank you for your wonderful support. We will try to have something like this again next year, checking some of the interesting issues across Africa that appear to be unclear or controversial, and bringing it back here and getting some experts to try to help us complexifying it.